friends, let's continue with our journey on legal languages in this episode number 5. Now there are various terms used like stay order, injunction, adjournment whenever the suit or case is filed in the court. Now what are all these? Let's see them in brief. Stay order. A stay refers to the postponement or halting of further proceedings in a given case, which is pending before that court of law. A stay order is an order of the court to suspend all or part of the judicial proceedings in that court. Injunction. Injunction may be defined as the order of a competent court to 1. Forbid or restrain the commission of a or continuation of a threatened wrong. 2. Forbid or restrain the continuation of a wrong which is already begun. And 3. Command the restoration of status quo. There are two types of injunction. One is temporary injunction and other is permanent or perpetual. Perpetual injunction is a final outcome of a court contained in a decree passed by that court. Adjournment. Adjournment meaning break off until later. Court at any stage of the suit may grant time to any of the parties by adjourning the hearing of the suit if sufficient valid cause is shown for doing so. The court fixes the next date of hearing in such cases. Now, what is cause of action? It is the entire set of facts which give rise to an unforeseen claim or enforceable claim. It forms the foundation of the suit. Thus, cause of action means every fact which plaintiff has to prove in order to support his right to the judgment of the court. Thus, there can be no suit without cause of action. Cause of action does not include evidence. Please note. Now, issues. What are the issues? Issues is said to arise when a material proposition of fact or law is affirmed by one party and denied by the other. That means there is a conflict within the two parties. Each of these propositions affirmed by one party and denied by other constitutes a distinct and separate issue. Issues can be classified into two. One is issue of facts, second is issue of law, and also the third one is mixed issue of fact and law. Court frames the issues on the basis of which decision would be based. The main object behind framing the issue is the record precisely the points of disagreements between the parties. Amendment of issues at any stage before the decree is passed is possible. What is ex parte decree? Ex parte decree is a decree passed by court in absence of the defendant. Thus, if in spite of the reputed summons, defendant do not appear in the court may proceed with the suit ex parte in his absence, and if the plaintiff proves his claim, court may pass decree in favor of the plaintiff. A defendant can apply to same court for setting aside the ex parte decree if he has a valid reason. Such application must be filed within 30 days of the ex parte decree. Many times we hear a term called Amicus Curie. What is it? Amicus Curie means in Latin a friend of court. He is not party to the suit, but his sole function is to advise the court or make suggestions to the court. He is appointed by court only to assist it in some particular aspect of the case. Now, what is decree? Decree is a formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the right of the parties with regard to all or any of the matters in controversy in the suit. Decree holder means any person in whose favor a decree has been passed or an order capable of execution has been made by the court. decree must satisfy the following conditions. There must be an adjudication. It means if there is no adjudication or trial in the court, decree cannot be passed. Second is, adjudication must be in a suit. Third, the adjudication must have determined the rights of the parties with respect to controversies, all or any of it, of the suit. Fourth is, such determination must be conclusive in nature. Fifth is, there must be formal expression of such adjudication. A decree can be preliminary or final. What is judgment? Judgment is a statement by the judge on the grounds of decree or order. The judgment is in all matters, civil as well as in criminal. What is appeal? Appeal means a complaint to a superior court of the injustice committed or error committed by an inferior court. Thus, appeal is the judicial examination by a higher court of the decision of the lower court. There is a detailed procedure given in CPC and CRPC for appeal, which is Civil Procedure Code and Criminal Procedure Code. As you are all aware, these civil procedure and criminal procedure are perfectly codified laws in India. Appeals lie to the Supreme Court in India in following cases. 1. Appeals from High Court in civil matters. 2. Appeal from High Court in criminal matters. 3. Appeal from High Court in constitutional matters. And 4th is special leave appeals, which is also called SLP, wherein a Supreme Court in its discretion can grant special leave to appeal for judgment, decree, sentence or order of a lower court. That is called special leave appeals, which is SLP, special leave petition also. Now, what is reference? There are 3 types: reference, revision and review. Now, what is reference? Under Civil Procedure Code, a subordinate court may stay a case and refer the same to the opinion of the High Court when it is of the view that there exists some doubt about question of law. So the lower court itself refers the matter to the higher court, High Court, which is called a reference. What is review? Review is an application for reconsideration of the matter before the court by the same judge. Review can be sought when 1. There is a discovery of new and important matter or evidence, and 2. Some mistake or error apparent on the face of the record, and 3. Any other sufficient reason. That means review lies with the same court. 3rd is revision. Now, Civil Procedure Code provisions empower High Court to interfere in revision of any case decided by a subordinate court, which is in specific circumstances. This is when no appeal lies to the High Court, or High Court finds that the subordinate court has exercised jurisdiction not vested in it, failed to exercise jurisdiction which is vested in it, or acted illegally or with material irregularity. High Court has power to act suo motu or on application by any party. This also we have seen in the writ of prohibition in last episode. Friends, we stop here and we'll continue in next episode further.